welcome to the deep dive. You're curious about the nitty-gritty of buying and selling stuff, the legal bedrock of commercial deals.
That's right.
So today we're plunging into the Sale of Goods Act of 1930. Think of this as, well, your cheat sheet for understanding the rules when it comes to movable property.
Exactly. We've taken a hefty business law textbook and really pulled out the key bits of this legislation.
The core principles.
Yeah, the fundamental principles that, govern how we exchange goods every single day.
Okay. So our mission today, let's crack open these core concepts. What actually counts as goods, legally speaking? And what's the crucial difference between a sale and just an agreement to sell?
A very key distinction.
And importantly, what does this all mean for you? Whether you're, buying your coffee or sorting out a big business contract?
Absolutely.
We've even found some surprising things included in that definition of goods, and we'll try to nail down exactly when ownership officially changes hands. Right, let's start with the basics. What actually gets classified as goods under this act?
Okay, so the Act uses a pretty wide net, actually. Goods are essentially every kind of movable property.
Movable, got it.
But there are a couple of key exceptions. Things like a debt someone owes you that's an actionable claim.
Right.
And, regular money, currency in circulation. That's not goods.
Okay.
But here's where it gets interesting. The definition specifically includes things you might not immediately think of.
Like what?
Like stocks and shares, for instance. Or crops growing in a field.
Growing crops? Seriously?
Yep, growing crops, grass, even things attached to the land if there's an agreement to separate them before the sale.
Wow. So if I agree to buy a farmer's wheat that's still in the ground, ready to harvest, that counts as goods.
That's exactly right. Legally speaking, yes. And it can stretch even further. Sometimes, depending on the interpretation and how it connects with broader contract law, even things like fixed deposit receipts might be considered goods.
FDRs. Okay, that is broader than I expected. So it's not just tangible stuff, things you can hold.
Good point.
Yeah.
No, it's not. The definition also pulls in intangible goods.
Intangible? Like what?
Think about goodwill, the value of a business's reputation,
Okay.
or copyrights, patents, trademarks, those kinds of intellectual property.
Right.
And even things like, gas, steam, water, electricity.
Electricity.
Yeah, even electricity. And believe it or not, even court decrees can fall under this definition.
Okay, electricity as goods. That really changes perspective. So a very broad definition. How does the Act then sort of organize all these different types?
Well, it mainly categorizes them based on whether they exist and how specifically they're identified when the contract is made.
Okay,
The first main category is existing goods.
existing goods.
These are goods that are, actually around. The seller owns them or has them or has acquired them when the contract is formed.
And I assume there are subcategories within that.
Exactly. Existing goods break down further into specific, ascertained, and unascertained goods.
Okay, let's take specific goods first. What are they?
Specific goods are the ones that are identified and agreed upon right at the moment the contract is made.
So very precise.
Very precise. Imagine buying, say, that specific blue smartphone with 256 gigs of storage. That particular phone is the specific good.
Or like a vintage car with a specific VIN number.
Perfect example. It's identified uniquely from the get-go.
Okay, that's clear. Now, ascertained goods sounds similar, but different.
It is similar, but there's a key difference in timing. Ascertained goods are goods that get identified after the contract is already made.
After, how does that work?
Typically, it involves picking them out from a larger, initially unspecified group. Think of a merchant agreeing to sell you 50 bolts of cotton fabric from their warehouse.
Okay.
The contract is made for 50 bolts. Then later, those specific 50 bolts are selected and set aside for you. Then they become ascertained goods.
I see. So they become specific after the deal is struck.
Right. And it's worth noting, the textbook mentions that in practice, legally, ascertained goods are often treated very much like specific goods.
Okay, so specific is identified at contract time, ascertained is picked out later. What about unascertained goods?
Unascertained goods are those where, at the time of the contract, they're only described maybe by sample, but no particular item is singled out.
So more general.
Exactly. Think about buying, say, one bag of salt from a supermarket shelf full of identical bags. You haven't picked which bag yet.
Right.
Or agreeing to buy one horse from a stable of 10 horses that all match a general description. Until a specific bag or a specific horse is chosen and set aside, the goods remain unascertained.
Got it. No single item is locked down initially. Okay, the Act also talks about future goods. What's the deal there?
Future goods are, well, exactly what they sound like. Goods that the seller is going to manufacture or produce or acquire after the contract is made.
So they don't exist yet, or the seller doesn't have them yet.
Correct. And because of that, this is really important. A contract for future goods is always considered an agreement to sell, not an actual sale at the time the contract is made.
Ah, okay. Why is that?
Simple logic, really. You can't immediately transfer ownership of something that doesn't exist or that you don't possess yet.
Makes sense. Can you give an example?
Sure. If a farmer agrees today to sell you their entire apple harvest from next autumn, those apples don't exist yet.
Right, so that's future goods.
Exactly. Or a contract to sell all the milk that a particular herd of cows will produce over the next 6 months. That's also future goods.
Okay, so future goods are things coming later, and the last category mentioned is contingent goods. How are they different?
Contingent goods are a bit like future goods, but their acquisition by the seller depends on some uncertain event, contingency.
So it might or might not happen.
Precisely. And just like future goods, deals involving contingent goods are also just agreements to sell initially. Ownership doesn't transfer until and unless that condition is actually met.
So the sale itself is conditional.
That's right. For example, imagine someone agrees to sell you a rare painting, but only if they manage to buy it themselves at an upcoming auction.
Ah, the sale depends on them winning the auction.
Exactly. That's a contract for contingent goods. Or, another one, agreeing to buy a shipment of goods only if the ship carrying them arrives safely in port.
If the ship sinks, no deal.
No deal. The contingency failed.
Okay, that clarifies the different types of goods really well. Now, let's dig into something absolutely fundamental. The difference between a sale and an agreement to sell. This feels really crucial.
Oh, it absolutely is. It's foundational. The core difference boils down to when the ownership, the property of the goods passes from the seller to you, the buyer.
Okay, where does it pass?
In a sale, the property, the ownership, transfers immediately, right when the contract is made. Boom, you're the owner.
Instantly.
Instantly. But in an agreement to sell, the ownership transfer is set for a future time, or depends on certain conditions being fulfilled first.
So sale, instant ownership. Agreement to sell, ownership later, maybe?
That's a good way to put it, yeah. Ownership later, or ownership if something happens.
The textbook mentions Section 4 of the Act defining this. What's the essence of that?
Section 4 basically just spells this out legally. It says a contract of sale involves the seller transferring or agreeing to transfer ownership for a price.
Right.
Then it clarifies, if the ownership transfer is right then, it's a sale. If the transfer is postponed or conditional, it's an agreement to sell.
And that agreement becomes a sale later.
Exactly. The Act says an agreement to sell becomes a sale when that future time arrives or when those conditions are met.
Okay, all about the timing and the ifs.
Mhm.
Now, for a valid contract of sale to even exist, what are the essential ingredients?
Good question. The textbook lists several key elements that have to be there. First, you need at least two different parties.
A buyer and a seller.
Right. Can't sell it yourself.
Yeah.
Second, the subject matter must be movable goods existing or future, as we discussed.
Okay.
Third, there must be a price, and it has to be in money, though it can be partly money and partly goods.
Like a trade-in. Trading my old car plus cash for a new one.
Exactly. That still counts as a sale under the Act.
Good to know. What else?
Fourth, there must be that transfer of property, or at least an agreement to transfer it. This usually happens through an offer and acceptance,
Standard contract stuff.
pretty much.
Ugh.
Fifth, the contract can be absolute, straightforward, no conditions, or it can be conditional, like with contingent goods.
Right.
And finally, all the other essential elements of any valid contract must be present. Things like free consent from both sides, legal capacity, a lawful purpose for the contract, and lawful consideration, which is the price.
So it's basically a standard contract, but specifically about movable goods and shifting ownership. Now, that comparison table in the textbook distinguishing sale from agreement to sell seems really helpful. Can we walk through those key differences?
Absolutely. Let's start with the big one, transfer of property. As we said, in a sale, it's immediate. In an agreement to sell, it's future or conditional.
Got it.
This directly affects the nature of the contract. A sale is seen as an executed contract.
Executed, meaning done.
Essentially, yes. Ownership is passed, the main thing is done. An agreement to sell is executory things still need to happen, like future payment or the actual transfer.
Okay, executed versus executory. How does that impact remedies? if someone breaks the contract?
This is a major practical difference. In a sale, because you, the buyer, already own the goods, if you don't pay, the seller can sue you directly for the agreed price.
Makes sense. They're suing for payment for your property.
Exactly.
Huh.
But in an agreement to sell, ownership hasn't passed.
Right.
So if one party backs out, say the buyer refuses the goods, the seller usually can only sue for damages.
Meaning the financial loss they suffered.
Right. The loss they incurred because the deal fell through. Unless, of course, the contract specifically said the price was due on a certain date anyway, regardless of delivery.
Okay. What about liability for loss? If the goods get destroyed after the contract but before delivery?
Generally, risk follows ownership. So, in a sale, since ownership passed immediately, if the goods are lost or damaged after that point, it's usually the buyer's loss.
Even if I haven't picked them up yet?
Often, yes, because you own them. But in an agreement to sell, the seller still owns the goods, so they typically bear the responsibility if the goods are lost or destroyed before ownership transfers.
That links to the next point, doesn't it? Burden of risks.
Precisely. Sale. Buyer bears the risk. Agreement to sell. Seller bears the risk, generally speaking.
That's a huge difference. So if the warehouse burns down, my problem if it was a sale, the seller's problem if it was just an agreement.
That's the usual outcome, yes.
Yeah.
It highlights why the distinction is so important.
Definitely. What about the nature of rights created? The textbook uses Latin terms.
Right, jus in rem and jus in personam. A sale creates a jus in rem for the buyer,
Meaning?
a right against the whole world concerning those specific goods. Because you own them, your right is good against everyone.
Like owning my phone right against anybody taking it.
Perfect analogy. An agreement to sell, however, creates only a jus sense in persona.
Which is?
A right against a specific person, the other party to the contract. It's the right to compel them to fulfill their promise, like transferring the goods later.
So right against the world versus right against one person.
That's the essence of it.
How does this affect the right of resale? Can the seller just sell the goods to someone else?
Once a sale is complete, the seller cannot legally resell those same goods because they no longer own them.
Makes sense.
But in an agreement to sell, since the seller still owns the goods, they technically could resell them to a third party.
But wouldn't that break the original agreement?
Oh, absolutely. It would likely be a breach of contract, and the original buyer could sue the seller for damages. But the second buyer might still get good title if they bought in good faith. It gets complicated.
Okay. And finally, the table mentioned insolvency. What happens if the buyer or seller goes bankrupt?
This is crucial too. If the seller goes bankrupt after a sale, their official receiver can't claim the goods back because you, the buyer, own them. Yeah, but the receiver can come after you for any unpaid price.
Right.
Now, if the seller goes bankrupt after an agreement to sell, but before ownership passes, the receiver can usually claim the goods as part of the seller's assets. You might lose any money you've prepaid.
Ouch. Okay, what if the buyer goes bankrupt?
If the buyer becomes insolvent after a sale, the goods are theirs, so their receiver takes control of the goods as part of the buyer's assets. The seller just becomes a creditor for any unpaid price.
And if the buyer goes bankrupt before ownership passes in an agreement to sell?
And the seller still owns the goods, so the buyer's receiver generally can't claim them. The seller might refuse to deliver unless they get paid.
Okay, these distinctions have really serious consequences. Now, the textbook also contrasts a sale with other similar deals, like hire purchase. How is that different?
Hire purchase looks a bit like paying in installments, but the key difference is ownership. In a sale, ownership can pass right away, even if you pay later. In hire purchase, you're essentially hiring the goods with an option to buy them at the end.
So I don't own it until the very last payment.
Exactly. You only get the option to purchase after all installments are paid. Until then, you can't legally sell the item to someone else because you don't own it. It's like a long-term rental that might become a sale.
Okay, renting with an option to buy. What about sale versus bailment?
Bailment is totally different. That's when you deliver goods to someone for a specific purpose, on the understanding they'll be returned or dealt with as you instruct.
Like leaving my coat at a club.
Perfect example. Or lending a book to a friend, or giving your watch to be repaired. The absolute key is ownership does not transfer in bailment.
Whereas ownership transfer is the whole point of a sale.
Precisely. And consideration is different too. Bailment can be free, lending a book, or payment for a service, watch repair. Sale involves a price for the goods themselves.
Clear. And the last one, sale versus a contract for work and labor.
This comes down to the main substance of the contract. Is the primary purpose the transfer of goods for a price, or is it the exercise of skill and Well, if you give gold to a jeweler to make a specific ring for you, the main thing you're paying for is their skill and effort in making it.
Even though I get a ring.
Yes, because the essence is the work. Similarly, commissioning an artist to paint your portrait. You get a painting, but the contract is primarily for their artistic labor and skill. It's usually working labor, not a sale of goods. The paint and canvas.
Ah, okay, so it depends on whether the skill or the item itself is the main point.
That's a good way to think about it.
Got it. Let's just back to how a contract of sale actually gets formed. Section 5.
Yes, Section 5 outlines how it can happen. It's pretty flexible. It can be a simple offer to buy or sell and acceptance.
I know.
Delivery and payment can happen immediately. Or delivery now, payment later. Or payment now, delivery later. Both.
So lots of options.
Yep. It can even be agreed that payment or delivery will happen in installments. And as I mentioned, even that trade-in scenario of goods plus cash forms a contract of sale.
Very flexible. And revisiting the subject matter, anything else key there?
Just reinforcing that it can be existing goods or future goods or even contingent goods.
Right.
And remembering that crucial point about specific goods, if they perish before the contract is made, without the seller knowing.
The contract is void.
Exactly. The deal's off from the start, because the specific thing agreed upon didn't exist at the time of the agreement.
Seems fair. Okay, let's talk price, the money aspect.
Absolutely essential. Section 210 defines price simply as the money consideration for the sale. No money, no sale under this act. It might be barter or gift.
Does the price have to be fixed right at the start?
Not necessarily. The Act allows flexibility here too. Section 9 says the price can be fixed in the contract itself.
Okay, the obvious way.
Or the contract can specify a manner for fixing the price later. For example, agreeing that a third-party valuer will set the price.
Ah, like getting an expert appraisal.
Exactly. Or the price might be determined by the established course of dealing between the parties, if they have a history.
Based on past transactions.
Right. And Section 10 deals with what happens if that third-party valuer fails to act in point. The agreement might become void, or if one party prevents the valuation, they could be liable for damages.
So, several ways to establish the price. Now, delivery. Getting the goods to the buyer.
Defined in Section 2.2 as the voluntary transfer of possession from seller to buyer. It's about putting the buyer in control.
And this idea of deliverable state. What's that?
Section 2.3 says goods are in a deliverable state when they're in such a condition that the buyer would, under the contract, be bound to take delivery of them.
Meaning they're ready as agreed.
Pretty much. The textbook uses an example of buying timber that needs bundling. The seller has to actually bundle it before it's in a deliverable state. Until then, the buyer doesn't have to accept it.
Okay, ready for handover according to the contract. What about these documents of title to goods? They sound important.
They are very important, especially in commerce. Section 2.4 describes them. They essentially act as a proxy for the goods themselves.
How so?
They represent possession or control of the goods. Crucially, transferring the document can be legally equivalent to transferring possession of the actual goods.
So you can trade the paper instead of moving the cargo.
In many cases, yes. Examples given include a bill of lading,
For shipping.
right? Dock warrant, warehouse keeper certificate, railway receipt. The list isn't exhaustive. Any document used in the ordinary course of business as proof of possession or control, or that authorizes the holder to receive the goods, counts.
Like the keys to the goods, almost.
That's a great analogy. The textbook highlights a key feature, though. It must show an unconditional undertaking to deliver the goods to the holder.
Unconditional promise.
Yes. That's why something like a mate's receipt, which just acknowledges goods are on board, isn't usually a document of title. It doesn't typically carry that unconditional promise to deliver to the holder. A bill of lading usually does.
Subtle but important distinction. Okay, well, this has been a really thorough exploration of the foundations of the Sale of Goods Act.
It has been quite a journey, hasn't it?
Yeah.
We've gone from the basic definition of goods, which is surprisingly wide,
Yeah, electricity.
to the absolutely critical difference between a sale and an agreement to sell. And we've broken down how goods are classified existing, future, contingent, specific, unascertained.
And how it all differs from things like hire purchase or bailment, plus the mechanics of price and delivery.
Exactly, a lot of ground covered.
It really is striking, isn't it, how this law from 1930, originally part of the Indian Contract Act from way back in 1872, still underpins so much of modern commerce. That broad definition of goods really brings it home and touches almost everything we buy and sell.
It It does. And those distinctions we talked about, like specific versus unascertained goods, they have real teeth when it comes to figuring out who owns what, when, and who bears the risk if things go wrong.
Definitely feels like there's more to unpack there in future.
For sure. Transfer of property and risk are big topics themselves.
So here's a final thought to leave you with. We live in this increasingly digital age, right? We trade in software, data, streaming access, things you can't touch. Delivery is often instantaneous, electronic.
A very different world.
How well do these traditional concepts, movable property, delivery, possession, really map onto this digital reality? The core principles of agreement, consideration, transfer. They still seem relevant, but their application must be evolving, surely.
It's a constant challenge for the law.
This act provides the framework, but technology pushes the boundaries. So what other areas of law do you think are being fundamentally challenged or reshaped by the sheer pace of technological change today?
That's a great question.
Let us know what you think. Your questions and ideas really do guide where we head next.
Automatic, isn't it? That moment you exchange money for something you want or need.
Yeah, totally.
But have you ever stopped to think about what's really going on legally in that simple act? Buying, selling. Turns out there's a whole, intricate structure under the surface.
Absolutely. And that's exactly what we're plunging into today. We're taking a deep dive into the Sale of Goods Act 1930.
1930.
Wow, I know that sounds like it belongs in a history book, maybe.
A bit dusty.
A bit. But this piece of legislation is, well, it's truly fundamental. It's the quiet force shaping almost every transaction involving goods, from grabbing your morning coffee to much bigger deals.
Right. And the reason we're exploring this particular act is actually thanks to one of you listening.
Oh, nice.
Yeah, someone with a wonderfully curious mind shared a bunch of fascinating material on it. So, our mission today is to sort of unpack the core ideas, strip away the legalese, maybe, and really focus on what's crucial for you to understand, whether you're the buyer or the seller.
Yeah, make it practical. The material you sent our way, it touches on so many vital areas. We're looking at the basic building blocks, the definitions, that the whole act rests on.
Okay.
Right through to the more complex stuff, the precise moment of ownership changes hands.
Oh, that's a big one.
And what happens when a deal doesn't quite go as planned?
So don't worry, we're not aiming to turn you into a courtroom expert by the end of this.
Definitely not.
What we want is to give you a solid, practical understanding of the key principles. We'll keep the jargon, we'll try to keep it minimal,
Yeah.
and focus on the stuff that really impacts your everyday experiences. Okay, let's get into it. Where should we even begin with this foundational law?
Well, a natural starting point is probably with the definitions the Act itself provides. Section 2 is like a mini dictionary of key terms.
Okay.
And getting a handle on these is, well, pretty essential for understanding everything else.
Right. So, who are the main players? We've got the buyer and the seller. Seems obvious, but the Act does define them, doesn't it? Section 2.1 and 2.13.
It does. A buyer is someone who buys or agrees to buy goods, and a seller is someone who sells or agrees to sell goods. Pretty straightforward, as you say.
Fair enough. But then we get to goods itself in Section 2.7, and that's where it gets maybe surprisingly broad.
It really is. What's fascinating here is just how wide that net is cast. Goods means every kind of movable property other than actionable claims and money.
Movable property. Okay.
So basically, if you can pick it up and move it, and it's not basically an IOU that needs a court to enforce,
Right.
or the actual cash in your wallet, it's likely considered goods under this act.
And it gets more specific, right? It actually lists things like stock and shares, growing crops, grass, and things attached to or forming part of the land, which are agreed to be severed before sale.
Exactly. So even that apple tree in your yard could be goods if you agree to sell it to someone who's going to come and dig it up. And there have been some really interesting interpretations in the courts, like lottery tickets.
Lottery tickets, seriously.
Yeah. The Supreme Court actually ruled they count as goods, not just a claim to a potential prize.
Wow. Who would have thought?
It highlights the sort of tangible aspect. You're buying that physical piece of paper, which represents a chance.
Okay.
Then you've got the ongoing discussions around things like water, gas, electricity. Are they goods?
Yeah, that's tricky.
Some early cases debated it, but the Supreme Court eventually leaned towards saying that electricity, because you can transmit it, store it, sort of possess it, it fits the bill as goods.
That makes sense when you think of it as something you pay for and receive measure. Now, you mentioned money and actionable claims are excluded. Can we clarify those a bit?
Sure. Money here means the official currency, banknotes, coins, but if you're dealing with rare coins, like collector's items,
Right.
those could be goods because you're trading them for their collectible value, not just as currency. And an actionable claim, think of it like an unpaid debt someone owes you. It's a right. You have to recover money, but you'd probably need to go to court to enforce it.
Right. Like an invoice.
Exactly. The Act says you can't sell that right to sue under this law, though you could transfer the debt itself in other ways.
Got it. So generally, if it's movable and tangible, it's goods. What other key terms should we have in our vocabulary for this?
We should definitely touch on future goods and specific goods, section 2.6 and 2.14.
Yeah.
Future goods are things the seller doesn't own or even possess yet when you make the deal.
Like something custom made.
Yeah, exactly, like a carpenter agreeing to sell you a table they haven't started building yet. Specific goods, on the other hand, are clearly identified and agreed upon right when you make the deal.
That particular painting in the gallery?
Precisely, that one with that title.
And it sounds like that distinction, future versus specific, could really affect when ownership changes hands, couldn't it?
Absolutely. We also need delivery, section 2, which is just the voluntary transfer of possession,
Okay.
and deliverable state, section 2.3, meaning the goods are ready for you, the buyer, to be legally required to take them.
Right. They're good to go.
Then price, section 210, specifically the money consideration. If you're trading goods for goods, that's more like barter.
Not covered here.
Not directly by this act, no. And finally, property, section 211, meaning the general ownership, not just who's holding them.
Right. Ownership versus possession, two different things.
Crucial distinction.
Okay, so we've got the basics of what's being traded and who's involved. How does the act define the overall deal itself?
That brings us to section 4, the contract of sale of goods. It's basically an agreement where the seller transfers or agrees to transfer the property and goods to the buyer for a money consideration called the price.
Okay, so it covers both immediate transfers and agreements for future transfers.
Exactly. It's intentionally broad.
Right, so you need a buyer, a seller. The goal is transferring ownership of those goods. It has to involve money, the price, and importantly, all the other usual things for a valid contract need to be there too, right? Like offer, acceptance, consent.
Precisely. All the essentials from the Indian Contract Act still apply. Now, within this contract of sale, the Act makes a really important distinction between an actual sale and an agreement to sell.
Section 4 again.
Section 4 and its explanation, yeah.
Yeah.
In a true sale, the moment you make the contract, ownership shifts to you. You're the owner right then and there.
Like buying that sandwich. You pay, it's yours. Done deal. An executed contract.
Exactly. Perfect example. On the other hand, an agreement to sell is where you agree ownership will transfer later, or maybe when certain conditions are met.
Like that custom-made table again.
Right. It's more of a promise to sell. It's an executory contract. The deal isn't finalized yet in terms of ownership transfer.
So if I put a deposit on a sofa that needs to be made and delivered in 6 weeks, that's an agreement to sell until it actually arrives, and I sort of take full ownership.
Precisely. And this difference has some pretty significant consequences, like risk.
Yeah. Who bears the loss if something happens?
Generally, in an agreement to sell, if that sofa factory burns down before delivery, the seller usually bears the loss because they still own it.
Okay.
But if you've already bought the sofa outright, it's a completed sale and it's just waiting for pickup, and then the store has a fire. Well, you, as the owner, would likely bear the loss.
Even though it's still at their place. Wow.
Because ownership had already passed you.
That makes sense. Risk follows ownership usually. What about remedies if someone backs out of an agreement to sell?
If it's an agreement to sell and the seller fails to deliver, your main recourse as the buyer is usually suing for damages for any loss you suffer. But if it was a completed sale and they refuse to hand over goods you now own, you have stronger rights as the owner. You might even be able to sue to get the specific goods themselves.
Right, because they're yours. Okay, so sale equals ownership now. Risk usually buyers. Agreement to sell, ownership later. Risk usually sellers until then.
Got it. Now, our sources also highlight how a sale differs from other things that look similar, like bailment.
Right, bailment, section 148 of the Contract Act. That's when you hand goods over for a specific purpose, expecting them back.
Like lending your friend your lawnmower.
Exactly. The key difference from a sale is no intention to transfer ownership. It's always meant to come back.
Renting tools, checking your coat. bailment. Ownership stays put.
Spot on. Then there's the distinction between a sale and a contract for work and labor. This one can be a bit fuzzy sometimes.
Yeah.
The general rule is, if the main point is ending up with a newly created thing for money, it's probably a sale. But if the focus is more on the skill, the effort involved.
Like hiring an artist to paint a portrait. That's a classic example. Even if they supply the canvas and paints, you're primarily paying for their skill and labor. So that's usually a contract for work and labor, even though you get ownership of the painting eventually.
Okay. And finally, hire purchase agreements.
Ah, yes. These often look like sales paid in installments.
They do.
But the crucial difference is that option to buy. In hire purchase, you, the hirer, only have the option to buy at the end, after all the payments. Until then, you're essentially just a fail.
So you don't own it until the very last payment.
Correct. And because you don't own it, you generally can't sell it to someone else and give them good title.
Even if they don't know it's hire purchase.
Generally, no. The original owner is protected. And that also affects risk.
How so?
In a regular sale with installments, you usually own it from the start, so the risk is yours. In hire purchase, because ownership hasn't fully transferred, the risk often stays with the original owner until you complete the purchase.
Okay, that clarifies those distinctions. Now that we've got a good grasp of what goods are and the different deals, let's dig deeper into the actual subject matter of sale. We've touched on existing, future, specific goods. Can we flesh those out?
Certainly. So, existing goods, seller owns or possesses them now. These can be specific, that one identified item.
The gallery painting again.
Yep. Or they can be generic or unascertained, defined only by description, like 10 tons of Grado wheat.
Not which 10 tons yet.
Exactly. They become ascertained when specific items are identified and set aside for the contract, and both sides agree, okay, these 10 tons.
Like my florist example earlier, ordering a dozen roses, initially unascertained. Then they pick 12 specific ones for me. They become ascertained.
Perfect. Then we have future goods, as we said, to be made or acquired later, and contingent goods, a type of future good where the sale depends on something uncertain happening.
Like agreeing to sell a rare book if you win it at auction.
Precisely. And remember, a true sale, immediate ownership transfer, can only happen with specific existing goods. Anything involving future or contingent goods starts as an agreement to sell.
Because you can't transfer ownership of what you don't definitively have yet. Makes sense. Now, what if those specific goods we've agreed on get destroyed or damaged? The effect of perishing of goods, sections 7 and 8.
Right, it depends when they perish. If specific goods perish before the contract is even made and neither party knew.
Like that vintage record player smashed yesterday, but we agree to buy-sell it today, unaware.
Then the contract is void. Mutual mistake. Neither party could fulfill the deal for those specific goods.
But what if the seller knew it was smashed?
Well, then they likely couldn't rely on the perishing to void the contract. And perishing isn't just total destruction. It can mean damage so bad they've lost their commercial character.
Okay. What if they perish after we have an agreement to sell, but before the risk passes to me?
Section 8 covers that. If specific goods perish after the agreement, but before risk passes, and it's nobody's fault, the agreement is also voided.
But only for specific goods.
Yes. If it was an agreement for unascertained goods, say 100 bags of cement, and the seller's current stock gets flooded, they generally still have to find 100 bags elsewhere to fulfill the contract.
Because the deal wasn't tied to those exact bags. Got it. Let's move to price. Sections 9 and 10, we know it's money, but how is it set?
Several ways. First, it can just be explicitly stated in the contract, fixed price.
Simple enough.
Second, the contract might outline a method for fixing it later, maybe tied to a market rate on a certain date, or a valuation process.
What if you agree a third party will set the price?
Section 10 deals with that. If that third party fails to do the valuation, the contract is usually void. Unless you, the buyer, have already received and used some of the goods, then you'd have to pay a reasonable price for what you've benefited from.
And if the third party's failure was someone's fault?
Then the party at fault could be liable for damages to the other party.
What if the contract just doesn't mention price at all?
Then Section 9 kicks in. The buyer must pay a reasonable price.
And reasonable usually means?
Usually the market price at the time and place of sale. It's a question of fact in each case.
Okay, price can be fixed, calculated, set by a third party, or just be reasonable. Now, a huge part of buying is knowing what you're getting. Conditions and warranties, sections 12 to 17. These sound like promises. Well, what's the legal difference?
It's a crucial difference. When you're making a deal, statements are made. Some are just opinions, puffery.
Best car on the lot.
Exactly. But others become actual terms if you rely on them. The law calls these stipulations, and these stipulations are divided into conditions and warranties. It all hinges on how important they are to the deal.
So what makes something a condition?
Section 12 says a condition is something essential to the main purpose of the contract. It goes to the root of the deal.
A real deal breaker if it's not met.
Absolutely. If a seller breaches a condition, you, the buyer, have a significant right. You can repudiate the contract, reject the goods, get your money back, maybe even claim damages.
That's strong. So what's a warranty then?
A warranty is more secondary, collateral to the main purpose. Still a promise, but not fundamental.
Like the color of the car stereo's backlight, maybe.
Perhaps, depending on the context. If a warranty is breached, you can't just reject the goods and walk away. Your remedy is limited to claiming damages for the loss suffered because of the breach.
But you have to keep the goods.
Generally, yes. And the Act stresses it's the substance, not the label. Calling something a warranty doesn't stop a court from treating it as a condition if it's truly essential.
Okay. And timing. Time of payment isn't usually a condition, but delivery time can be.
Section 11 says time of payment usually isn't, unless specified. Time of delivery depends on the contract terms. It can be a condition if the contract makes it clear that time is of the essence, but often it's treated more like a warranty. A delay might entitle you to damages, but not necessarily rejection.
Got it. Now, Section 13 talks about when a condition sinks to the level of warranty. How does that happen? When does a deal breaker become just a claim for damages?
A few ways. First, you, the buyer, might just choose to waive the condition, say, okay, it's not exactly right, but I'll take it anyway. Or you might decide to treat the breach of condition as just a breach of warranty, perhaps claim a price reduction instead of rejecting. And thirdly, if it's an indivisible contract like buying a whole machine and you've already accepted the goods, even if they didn't meet a condition, you generally lose the right to reject. You can then only treat it as a breach of warranty and claim damages.
So acceptance is key there. Once you've accepted in an indivisible deal, you're mostly limited to damages for prior condition breaches.
Okay.
Besides these explicit promises, the law implies certain promises automatically, doesn't it? Let's start with implied warranties.
Yes, sections 14b, 14c, and 16.3 cover these. There's an implied warranty for quiet possession.
Meaning no one with a better claim will show up later.
Exactly. And an implied warranty that the goods are free from any charge or encumbrance you weren't told about.
Like an undisclosed loan on a car you just bought.
Precisely. Also, if goods are inherently dangerous, there's an implied warranty that the seller will disclose that danger if they know about it. And warranties can also be implied just by the custom of a particular trade.
So buying a used bike implies a promise it's not stolen and there are no hidden debts on it. Makes sense. What about implied conditions? These sound even more fundamental.
They generally are. Sections 14a, 15, 16. They list several key ones. The most basic is probably implied condition as to title under 14a.
The seller has the right to sell it.
Fundamentally, yes. They implicitly promise they have the right to sell or will have it when ownership is supposed to pass. If they don't, you can reject the goods and get a full refund, even if you've used the goods.
Like that stolen car case, Roland v. Duval. Buyer used it for months but got all his money back.
Exactly, because he never got legal ownership, which was the core of the deal. A total failure of consideration.
Wow. Okay. Crucial one. What else?
If you buy based on a description, Section 15 implies a condition that the goods shall correspond with the description.
Even if you saw them.
Yes, if you relied on the description. Like that case Beal v. Taylor, the car described as a 1961 model turned out to be two cars welded together. Breach of condition.
So it has to be what they say it is. What if I buy from a dealer, someone who normally sells that kind of thing?
Then Section 16.2 brings in the implied condition of merchantable quality.
Meaning?
Basically, fit for the ordinary purpose goods of that description are used for, and free from defects that would make them unsellable under that description.
But what if I check the goods first?
Well, the implied condition doesn't cover defects your examination ought to have revealed, but it still covers hidden defects you couldn't reasonably spot.
Like the black yarn with white ants inside example.
Right, you wouldn't spot that easily.
And wholesomeness for food.
Yes, an implied condition that edibles are safe and fit for consumption. Typhoid milk. Stone in a bun breaches of this condition.
Makes you cautious. What if I tell the seller I need it for a specific purpose?
Section 16.1. Implied condition as to fitness for a particular purpose. If you make the purpose known, show you're relying on the seller's skill and judgment, and they deal in those goods, then there's an implied condition the goods will be reasonably fit for that purpose.
Unless I ask for it by a brand name.
Right, then you're seen as relying on the brand, not the seller's advice. But otherwise, like the Priest v. Last case with the bursting hot water bottle,
He told the chemist what he needed it for.
and relied on the chemist's supply. So when it failed, it was a breach.
So telling the paint store I need durable exterior paint and taking their recommendation means it should be fit for that.
Exactly. And finally, sale by sample, section 17.
Okay.
If you buy based on a sample, there's an implied condition. The bulk will match the sample in quality, you get a chance to compare, and the bulk is free from hidden defects not apparent in the sample.
Right. And if it's sale by sample and description?
Then the goods have to match both. Like that rape oil case, nickel versus Gotts. It had to be foreign refined rape oil and match the sample.
That's a lot of implied protection. It really chips away at that old idea of caveat emptor, doesn't it? Let the buyer beware.
It does. Caveat emptor is still the starting point in Section 16 generally. No implied warranty or condition as to quality or fitness. The onus is on you, the buyer, to check things out.
Like the Ward versus Hobbs case with the diseased pigs that looked okay. Buyer's look out.
That's the traditional view. And that silk sari example, if the buyer just assumes it's expensive silk without asking and the seller doesn't lie, caveat emptor might apply.
But then there are all these exceptions we just discussed.
Exactly. The Act carves out big exceptions. False statements by the seller, actively hidden defects, fitness for purpose when relying on the seller, merchantable quality when buying by description from a dealer. These all shift responsibility back to the seller.
So buyer beware isn't absolute.
Not at all. And modern consumer law, like the Consumer Protection Act, plus the rise of online sales where you can't easily inspect.
Yeah, true.
It's all pushed towards more seller responsibility. The idea of caveat venditor, let the seller beware, has gained ground. It's more of a shared responsibility now.
A more balanced approach.
Okay.
Let's switch gears to something really practical. When does ownership actually transfer? The passing of property, sections 1825. Why is this moment so important?
Oh, it's crucial. As we said, risk usually follows ownership. So knowing who owns it tells you who bears the loss if it's destroyed.
Right.
Also, who can sue if a third party damages it? Who can legally resell it? And if someone goes bankrupt, are the goods part of their assets? It all depends on who owned them at that specific moment. And remember, ownership is different from just having possession.
Definitely. So for specific goods, the identified ones, when does ownership pass?
Sections 20 to 22 lay it out. Rule 1. If it's an unconditional contract for specific goods in a deliverable state,
Ready to go.
ownership passes when the contract is made. Right then. Doesn't matter if payment or delivery is later.
Like that machine destroyed by fire after the agreement but before pickup, ownership had passed.
Exactly. Rule 2, Section 21. If the seller still has to do something to the specific goods to get them into a deliverable state.
Like finishing repairs on that car.
Ownership doesn't pass until that work is done and the buyer is notified.
Okay, notification is key too.
Yes. And Rule 3, Section 22. If the goods are deliverable, but the seller still needs to weigh, measure, or test them to figure out the final price. Ownership doesn't pass until that's done and the buyer is notified.
So doing the act and telling the buyer. Got it. What about goods sent on approval or sale or return? Section 24.
Here, ownership passes when the buyer signifies approval or acceptance.
Yes, I'll keep it.
Or does something adopting the transaction, like reselling it, or if they just keep it beyond the agreed return time or beyond a reasonable time if no time was set, without rejecting it.
So silence or inaction after a certain point can mean acceptance and ownership transfer.
Pretty much. Now, what about unascertained goods? Section 23. Like our 10 tons of wheat.
Yeah, when does ownership pass there? It can't be when the contract is made.
No, because you don't know which 10 tons yet. Ownership passes when goods matching the description in a deliverable state are unconditionally appropriated to the contract.
Appropriated, meaning.
Set aside, identified, and dedicated to fulfilling that specific contract. And this appropriation needs the assent, the agreement of both parties.
How does that assent happen?
It can be expressed, yes, those are the ones, or implied. Crucially, delivering the goods to a carrier, like a shipping company, for transmission to the buyer is generally considered an unconditional appropriation.
Ah, so handing it over to FedEx counts.
Usually, yes, unless the seller reserves the right of disposal.
Reserves the right, like keeping control.
Exactly. For example, making the shipping documents deliverable only to their own order, or sending documents with a bill of exchange attached that the buyer must accept before getting the documents. Until those conditions are met, ownership doesn't pass, even if the goods are on their way.
Okay, so for unascertained goods, it's about identifying them, setting them aside with mutual agreement, often signified by delivery to a carrier unless the seller keeps control.
Yeah.
Now, closely related, passing of risk, section 26.
The default rule, as we keep saying, is res paret domino risk follows ownership. Once you own it, you bear the risk, usually.
Even if it's still in the seller's warehouse.
Even then, but crucially, the parties can agree otherwise.
So the contract can separate risk from ownership.
Absolutely. That coffee auction case showed risk could pass to the bidder immediately on acceptance, even before ownership. Or goods could be shipped at the buyer's risk even while the seller retains ownership until payment.
So the contract terms are key.
Very key. Also, if delivery is delayed due to the fault of either party, the party at fault bears the risk for any loss that wouldn't have happened but for the delay.
So fault can shift the risk too. Okay, now this is a big one. Transfer of title by non-owners, sections 2730. What happens if someone sells something they don't actually own?
The starting point is the Latin maxim, nemo dat quod non habet.
You can't give what you don't have.
Exactly. A seller cannot give the buyer a better title to the goods than they themselves possess. If you buy from a thief, you don't get good title. If you buy from someone hiring goods, you don't get good title.
Seems fair, protects the true owner. But our sources mention exceptions, situations where the buyer does get good title.
Yes, there are several important exceptions, mainly to protect innocent buyers in commercial transactions.
Okay, like what?
First, sale by a mercantile agent. If an agent who normally deals in goods has possession of them or documents of title with the owner's consent and sells them in the ordinary course of business to a buyer acting in good faith without notice of any lack of authority.
The buyer gets good title.
Yes, even if the agent exceeded their specific instructions, like selling below a set price.
Protects people dealing with dealers. Makes sense. What else?
Sale by a co-owner. If one joint owner has sole possession with the other's permission and sells to a buyer in good faith.
Good title again.
Yes. Also, sale by person in possession under a voidable contract.
Voidable, meaning the contract could be canceled, like due to fraud.
Right. If someone gets goods through fraud, their title is voidable. But if they sell those goods before the original owner voids the contract to an innocent buyer who pays value in good faith.
The innocent buyer is protected.
Yes, the innocent buyer gets good title. The original owner's remedy is against the fraudster, not the innocent subsequent buyer.
Important protection for buyers. Anymore.
A couple more key ones. Sale by seller and possession after sale. If a seller sells goods but keeps possession and then sells them again to a different buyer who acts in good faith.
The second buyer gets title.
Yes. Tough on the first buyer, but protects the second innocent one. Similarly, sale by buyer in possession. If a buyer gets possession with the seller's consent under an agreement to sell, like hire purchase sometimes, and then sells to a third party in good faith.
Third party gets title.
Often, yes. Then there's estoppel. If the true owner acts in a way that suggests the seller has authority, they can't later deny it. And an unpaid seller, exercising their right of resale, can give good title. Plus, sales under other laws, like by a pawnee or official receiver.
Okay, quite a few exceptions to Nemo Dat, mostly protecting good faith purchasers in common scenarios. Let's move to actually doing the deal. Performance of the contract, sections 3144.
Right. Basic duties. Section 31 says the seller must deliver the goods and the buyer must accept and pay, according to the contract terms. These are usually concurrent conditions unless agreed otherwise.
Pay on delivery, deliver on payment. Okay, delivery itself, sections 3339. It's not just physical handover, is it?
No, there's actual physical delivery. There's constructive delivery, where the person holding the goods acknowledges they now hold them for the buyer, like a warehouseman.
No movement, but a change in legal holding.
Exactly. And symbolic delivery, handing over something that represents control, like keys to the warehouse or a bill of lading for shipped goods.
And there are rules about how delivery should happen.
Yes. Seller must put buyer in possession. Delivery must match the contract. Buyer usually has to apply for delivery. If goods are with a third party, that party must acknowledge to the buyer they hold for them. Seller must tender delivery at a reasonable hour, places as agreed, or where goods are. Seller usually bears cost of putting goods in deliverable state. Risk of transit deterioration is usually buyer's unless agreed otherwise. Buyer isn't bound to accept installments unless agreed.
Okay, quite a checklist. What about the buyer's side acceptance? Section 42. How does a buyer accept?
3 main ways. 1, they tell the seller they accept. 2, they do something inconsistent with the seller's ownership, like reselling the goods or modifying them substantially. 3, they keep the goods for a reasonable time after delivery without telling the seller they've rejected them.
So inaction can count as acceptance again. What if the seller delivers the wrong quantity or description?
Buyer has options. Reject all, accept all, paying contract rate. Or accept the conforming goods and reject the rest.
And if I rightfully reject goods, do I have to send them back?
No, Section 43 says you're not bound to return them. You just need to inform the seller you're rejecting them. It's then up to the seller to collect.
Good to know. What if the seller is late delivering?
You can usually claim damages for loss caused by the delay. And remember that case, J&H Ritchie. Even if the seller tries to fix a defect, if it's still fundamentally flawed, the buyer can still reject.
Right, you don't have to accept a botched repair job. And installment deliveries, Section 38. If one shipment is bad, can I cancel the whole thing?
It depends. You have to look at the contract terms and how serious the breach is. Is it a one-off problem, or does it suggest the seller won't perform the rest properly? If it's serious enough to undermine the whole contract, you might be able to repudiate. Otherwise, it might just be a claim for damages for that faulty installment.
Okay, depends on the severity. Now, inevitably, sometimes things go wrong. Suits for breach of contract, Sections 55-61. What can the seller do if the buyer breaches?
If ownership has passed and the buyer hasn't paid, the seller can sue for the price, Section 55. They can also sue for the price if payment was due on a specific day, even if ownership hasn't passed. If the buyer wrongfully refuses to accept and pay, the seller can sue for damages for non-acceptance, Section 56.
And the buyer's remedies if the seller breaches.
If the seller fails to deliver, the buyer can sue for damages for non-delivery, Section 57. For breach of warranty, the buyer can't reject, but can claim damages, maybe deducting it from the price, Section 59. If the buyer paid but didn't get the goods, they can sue to recover the price. And in rare cases involving specific goods, they might get specific performance, Section 58, forcing the seller to deliver those exact goods.
What about anticipatory breach? Section 60. If someone says up front they're backing out.
The innocent party has a choice. They can either treat the contract as immediately broken and sue for damages right away, or they can wait until the performance date, treat the contract as still alive, and see if the other party performs. If they wait, the breaching party could still perform, or might find some other reason the contract ends.
Interesting choice. And how are damages calculated?
The Act points to Section 73 of the Indian Contract Act. The goal is compensation, put the injured party in the position they would have been in if the contract was performed. It's about the loss naturally arising from the breach.
Makes sense. Okay, let's focus on a specific character. The unpaid seller, Sections 45 to 54. Who counts?
Section 45. Someone who hasn't been paid the whole price, or whose payment, like a check, bounced.
Okay, and they have special rights against the goods themselves.
Yes, 3 main ones if they still have some control. A right of lien, a right of stoppage in transit, and a right of resale. Plus, the right to withhold delivery if ownership hasn't passed.
Let's break those down. Lien, Sections 47, 49, 54.
It's the right to retain possession of the goods until paid. Applies if sold without credit, credit expired, or buyer becomes insolvent. But the seller must have possession.
And they lose it
If they deliver to a carrier without reserving control, if the buyer lawfully gets possession, or if they waive the lien.
Okay, stoppage in transit, Sections 50, 52.
This applies after the seller has parted with possession but before the buyer gets them, and only if the buyer becomes insolvent. The seller can tell the carrier to stop the delivery and return the goods.
When does transit end?
When the buyer takes delivery, or the carrier acknowledges they hold for the buyer, or if the carrier wrongly refuses delivery.
And how do they exercise this right?
By retaking possession or just giving notice to the carrier.
Is this right affected if the buyer has already resold the goods while they were in transit?
Generally no, unless the seller consented to the resale. But if the buyer transferred a document of title, like a bill of lading, to a good faith purchaser for value, that can defeat the seller's right to stop.
Tricky. And the right of resale, Section 54.
An unpaid seller can resell if the goods are perishable, if they expressly reserve the right in the contract, or if they've exercised lien or stoppage and given the buyer notice of intent to resell, and the buyer doesn't pay within a reasonable time.
What happens to the money?
If they get less, they can sue the original buyer for the difference. If they get more, After giving proper notice, they can usually keep the surplus.
Okay, and what rights does the unpaid seller have against the buyer personally?
Same as we discussed before. Sue for the price, Section 55, or sue for damages for non-acceptance, Section 56.
Got it. Now quickly, auction sales, Section 64. Any key rules?
Yes. Each lot is a separate contract. Sale is complete on the fall of the hammer or similar. Bids can be retracted before completion. Seller can only bid if the right is expressly reserved, otherwise it's potentially fraudulent. Sales can be subject to a reserve price.
Good to know. Finally, those trading contracts involving transit, FOB, CIF.
Just briefly, FOB, free on board, seller gets goods onto the ship, risk ownership usually past them. Buyer normally names ship, seller notifies buyer for insurance.
Okay.
FOR, free on rail, similar but for rail.
Right.
CIF, cost, insurance, freight. Seller arranges and pays cost, insurance, freight. Buyer pays against documents, risk usually passes on shipment.
Seller handles logistics.
Yeah. X-ship, seller responsible right up to destination port. Buyer takes over on arrival before unloading. Seller bears transit risk.
Different ways to allocate costs and risks in shipping. Helpful overview. Wow, we have covered a lot of ground on the Sale of Goods Act.
We certainly have. From the basics of sale versus agreement to sell, through conditions, warranties, ownership, risk, it's quite the framework.
It really is. And understanding even the outlines of implied terms, when ownership passes, or what happens if goods perish, it's so relevant.
Absolutely. This 1930 Act, it underpins countless transactions every single day. Knowing the principles really does empower you, whether you're the buyer or the seller.
And we saw there are remedies for both sides if things go wrong. Plus, those specific rights for the unpaid seller.
A whole system designed, ideally, to make sure contracts are performed fairly and provide recourse when they're not.
So here's a final thought for you listening. Think about the last thing you bought. Could be anything. A coffee, a book, a car part. How many of these concepts, ownership, risk, maybe an implied warranty of quality, were quietly operating in the background of that simple transaction?
It makes you think, doesn't it? Perhaps it sparks some curiosity to look deeper into a specific area that affects you or your business.
Definitely something to mull over. Thanks for joining us on this deep dive.